Mr. Singer.
Good morning, my lords. As you know, I appear on behalf of the Meta defendants, along with Mr. White, and Mr. O'Donoghue and Miss O'Keefe appear on behalf of the class representative. My lord, I'd like to start by raising a housekeeping issue, if I may, which is that of timing. It would be useful for my part to know at the outset how much of this hearing your lordship envisages will be allocated to each party, because in my respectful submission, given your provisional views as expressed in the July order, the purpose of today's hearing is not to argue out the full appeal, but simply to persuade your lordship that there is an arguable point of law which merits full consideration, and on that basis I would respectfully suggest I should be entitled to the majority of the time this morning. Mr. O'Donoghue sees it slightly differently. He says he should have 50% of the time, and obviously I would ask your lordship to give some indication, plus a reply. He said 50% plus a reply, but I would ask your lordship just to give some indication, because
well, it seems to me analytically you're right. You've simply got to show it's arguable, and it's not rolled up or anything like that. I mean, how long do you need? If you had till 12 or 12:15 and Mr. Donoghue has half an hour, 40 minutes, then you've got 5 or 10 minutes for a reply?
That's exactly what I was going to suggest, my lord. So I'm hoping to sit down at around 12:15, allowing Mr. O'Donoghue half an hour, perhaps a shade more, and then 5 or 10 minutes for reply.
We've got a number of options. We could, at the end of the hearing, consult and then give you a decision with reasons to follow. We might want to rise, think about it. If so, we would be minded to give a result, possibly by email with reasons to follow, so you could, plan accordingly. The third alternative is we produce everything in a reasoned decision, but we'll consider that at the end of the day. If we can, we'd like to give a decision as soon as possible, so that people can just plan accordingly.
Of course.
Now, I know, Mr. O'Donoghue, that curtails you slightly, but this is a threshold case. We read the documents fairly thoroughly. We know, you know what your target is. We've read your skeleton, which is very helpful. We think, as we provisionally said, it's up to Meta to persuade us. Provisionally, we're with you. That's what we said. But you've got a chance to persuade us otherwise.
Yes, my lord, that's exactly how we see it. And of course, if this court grants permission, then of course the time allocation will be in the usual way at the main hearing.
Well, if you grant permission, we will send you off to do some directions.
My lord, I'm grateful. On that basis, can I start by reminding your lordships of the procedural context in which this application for permission to appeal arises? As you will have seen from the CAT's judgment, the tribunal initially refused to certify these proceedings. In its first judgment, it said that the class representative had failed the process test. But instead of dismissing the proceedings altogether, it granted the class representative the opportunity to have another go. And in response to that, they produced a substantially amended claim form with a new methodology from a new expert. Now, the amended claim, as you will have seen, is solely concerned with what the class representative terms off Facebook data, which she says is data concerning user activity off the Facebook platform. And it's alleged that Meta committed 2 abuses in relation to off Facebook data, charging Facebook users an unfairly high price and also imposing an unfair trading term. Now, the key point, my lords, is from a procedural perspective, is that when the case came back before the tribunal, what the tribunal had to consider was an application for permission to amend, and the issue, therefore, was whether the amendments had a reasonable prospect of success and satisfied the process test. Now, we say in granting permission to amend, the tribunal committed 2 errors of law. If I could perhaps start by summarising the grounds. Under ground 1, we say that the tribunal erred in granting the class representative permission to amend to pursue the alleged unfair price case. Now, the unfair price case in a nutshell is that Meta charged Facebook users an unfairly high price for the Facebook service by collecting their off-Facebook data without making what they term a corresponding value transfer. And we submit that the case is bad in law, and the reason it's bad in law is because it fails properly to apply the legal test applicable to abusive pricing as set out in the United Brands jurisdiction. That jurisdiction, well established and is common ground, requires that a claimant in an unfair pricing case must establish that the price, and I quote, bears no reasonable relationship to the economic value of the relevant product or service. And that concept of economic value was described by this court in At the Races as the central concept in unfair pricing cases. And consistent with that, more recently, as my Lord Justice Green well knows, in Flynn Farmer, this court said that a proper application of the United Brands test requires an evaluation of economic value, 172 of Flynn Farmer.
Somewhere.
Exactly. It's the underlying
Some point
concept.
in the analysis.
Exactly. Your Lordship said that the cat in that case was wrong to say it was a separate part of the test. It's the underlying concept which needs to be evaluated at some point through the other components.
What does that mean in a case like this? So, I mean, just trying to get my head around it from a practical perspective. Let's assume, for the sake of argument, that Facebook to users has a phenomenal value. We'll call it 100. Then you'd expect the user to pay something approximating to that. And in order to decide whether or not the on-Facebook data is sufficient in and of itself, you may have to look at the value of the service being provided, and it may include all or part or more than the off-Facebook data. But is it saying any more than you've got to have a correlation between what each party pays, because all transactions have a value to them?
No, well, I would respectfully agree with that. The question is...
Isn't that what Professor Morton and the pleading said?
No, and that's the fundamental point. Yeah, as your Lordship will see in the course of this morning, that really is the nub of it. We would accept that the test requires a comparison of a price, and that may require adaptation here because there's zero monetary price. We accept that. But it requires a comparison between the relevant price and the relevant product or service. And the relevant product or service, as your Lordship actually said, that the service is the Facebook service. And that's the fundamental problem in this case, because there is no attempt to value the full the economic value of the full Facebook service. No attempt whatsoever. And this is actually...
No attempt in the pleadings or in the report?
Either, my Lord.
Either.
Actually, the pleading is defective in the sense that it doesn't even address the economic value to users at all. So that's point one.
But they accept in terms that value has to play a part. I mean,
Well, this is, my Lord, this is the nub of it, because that's absolutely right. It's common ground what the test is. It's common ground they need to engage on economic value. But Professor Scott Morton expressly disavows any attempt to value the full Facebook service. I'll come to this in due course, because this is where, in my submission, the tribunal erred. It failed properly to understand the approach. In section 4.5 of her report, I'll obviously show you these paragraphs, but for your Lordship's note right at the outset, because this is the absolute crux of the case, at 253 of her report, she recognises that there is economic value predating the off-Facebook data tracking. I mean, she has to recognise that, because the off-Facebook data tracking for advertising purposes only started in June 2014. So she does at least acknowledge that there was this value predating off-Facebook data. But at 261, she goes on expressly to say that in her view, it is not the right approach to assess the aggregate value to users of the Facebook service. And so, my Lord, that really is, we say, demonstrative of the fact that they have framed their case in a way which is impermissible as a matter of law. Because yes, they are engaging on economic value, but they're not, in fact, asking the right question or aiming at the right target.
so what? I mean, so it's common ground that value is an issue, and the tribunal took the view that that was sufficient at the certification stage to get the case up and running, regardless of what happened at the trial itself. To what I mean, if there's a dispute about value, you may be right, you may be wrong on value. Why? How is that a matter of law as opposed to evidence for trial?
Because, my Lord, first of all, in relation to the tribunal's reasoning, the tribunal makes two errors. First, it misunderstands the approach. And this is why I need time this morning, because one only sees the point of law crystallised if one has a proper understanding of the expert methodology. So the tribunal, first of all, was wrong to say that the expert is taking account of the economic value of the whole Facebook service. Mr. O'Donoghue, in fact, repeats that point at paragraph 29D of his skeleton, where he cross-refers to section 4.5. But with respect, if one reads 4.5, that's the section where she says, I'm not going to assess the full Facebook service. I'll show you these paragraphs, my Lord, it's absolutely crucial. And the second point that where the tribunal erred is they said, oh well, United Brands is a flexible test. And that is obviously right in one sense, but the flexibility in my submission only arises as regards the methodology used to establish abusive pricing. It doesn't change what the basic test is or what the claimant needs to show. And so your Lordship's example that you put to me, if there was just a debate about, well, what is the economic value of Facebook to users, I would absolutely accept that would be a debate for trial, clearly. Certainly not a reason to disallow the amendment. But my Lord, here, there is a clear point of law that arises. Are you entitled to allege that there is an unfair price by taking essentially only a slice, an incremental aspect of the economic value, that part of the value that arises post the off-Facebook data tracking, and disregarding all of the economic value to users that existed prior to that? And are you entitled to take that incremental slice of economic value and measure it against what they describe as the price, namely the off-Facebook data? We say a proper approach, and there's not a single case, my Lord, that endorses or supports in any way this, what we've termed the incremental approach. All of the cases essentially proceed on the basis that what is required for economic value is a comparison of the whole price against the economic value of the whole product or service. You can't focus in on a particular point in time and say, well, in 2014, what they describe as the bargain between users and Meta changes, they say. They say it changed because suddenly off-Facebook data tracking started. And they say, therefore, at that moment, the price goes up, and they look at whether there was a corresponding increase in economic value. And she concludes there wasn't. And that's the fundamental defect, we say, because there is not, as I say, not a single authority that permits this incremental...
That's their methodology for establishing value or lack of it.
No, my Lord, with respect, it's their methodology for establishing the unfair price.
Okay, well that's... You throw value into the equation to decide whether a price is unfair or not.
Yes.
But they say that once the ATT initiative was started, you can do a compare before and afterwards. You can assume that the Facebook service was provided for consideration which was matching. You can then ask yourself what happened afterwards. And yes, there's a question of value to be factored in at some stage, possibly there. But they say there wasn't any. You dispute that.
Well,
so the question is this just methodology or is it law?
No, my Lord, can I just clear away one point? ATT doesn't really bear upon this. That's a specific tool which Apple introduced. And in my respectful submission, is somewhat of a red herring for the purposes of this debate, because they do use that to support some of what they say, but it's not at the core, as it were, of either the pleaded case or the methodology. The core case that's being advanced is that they are not going to, they are alleging an unfair price, just perhaps to take this in stages. They are alleging that there was an unfair price within the meaning of the United Brands jurisdiction. They accept that as a mandatory part of that exercise, per the Flynn Farmer decision, they need to ask the question of economic value. So far, so good. But my Lord, where the error comes in is that they say they are entitled to prove their case as to unfair pricing by only looking at that which takes place in 2014 onwards. So if one takes a step back and looks at this...
Is that actually correct if you look at 252 of her report to 264? Because...
Sorry, can I just grab, where is that?
Well, it's in the supplemental bundle, page 269. .5 is where the economic value issue arises. 255 sets out what Facebook was arguing. Look at the value to the consumers versus the thing overall. Various points are then made. And the 261, the author says, my view is that the right approach to assess the fairness of price is not to look at the aggregate value of Facebook to users, That's a shorthand reference back to what she says is Facebook's argument, but to assess whether Facebook has struck a fair bargain as it has increased its data extraction over time. And I don't see why that necessarily excludes looking at the value initially, but also looking at what has happened over time and the changes that have happened over time. I don't think that's a denial of that you cannot look at what was there initially.
Your Lordship's right that one, in theory, could look at economic value pre and post, but she does disavow looking at the value pre. And I'd like to take this.
In this report,
Well, my Lord, I need to show you quite a few paragraphs in this report, and I was going to come to actually quite a detailed analysis of this expert report, because this does actually lie at the heart of the application for permission to appeal. But just whilst I think I can see both of your Lordships have the relevant section open, at 253, one can see there the three buckets of economic value. Can you see Roman 1, 2 and 3? And it's Roman 1, value users received from using Facebook prior. And 2, value that occurred after but didn't require such tracking to occur. It's 1 and 2 that we'll see when I get to a more detailed review of the report. It's 1 and 2, Roman 1 and 2, which are, your Lordship's absolutely right, one could break it out in this way and measure the value of 1, 2 and 3 separately. I'm not taking that point, but what is absolutely clear from her report is that she is not intending to conduct an assessment of the economic value of Roman 1 and Roman 2. And if one, again, just I don't want to get ahead of myself, but if one looks at 265, the section there is all concerned with whether the data extraction by off-Facebook tracking, as she calls it, whether that could be justified by an increase in economic value. So it's exclusively focused on the period post, and not merely the period post, but economic value in that period post, which is attributable to the off-Facebook tracking. So my Lord...
She's not saying there that that's how you value it. What she's saying there is you, Facebook, might be able to justify it on one basis, i.e. that you got some extra new service in return for getting the data. She's not saying any more than that, is she?
No, but your Lordship, but my Lord, but she's already gone down the path of looking only at that period. So of course she's accepting, as she has to, that even on this incremental approach, if we have a fight about the value in the period post off Facebook data tracking, she's obviously saying I will have to deal with that. But there's an anterior point and a much more fundamental point with respect, which is, well, what about all of the economic value to users accruing before off Facebook data tracking occurred?
Can I put this, just ask you a procedural point, which struck me as interesting in the Catch judgment. They said that at the certification stage, it was wrong to anticipate the putative respondent's arguments. Now, you're putting some cogent points to us, which might fit into the category of things that shouldn't have to be anticipated, but which would have to be responded to later. Is that the case?
No, my Lord, no, with respect, because here, obviously I'm very aware of the case law on process and the court's explanation in the Trains case, for example, about not having to anticipate every single point. I understand all of that. But my Lord, here, one is dealing with an application for permission to amend. They therefore need to show that they have an arguable case, and a case, we say, that satisfies process. Now, if they have chosen to frame their unfair price case in a way that doesn't fit the legal framework, then that's not a question...
I understand that. I mean, if that's right. If this is poor law, and they've got it wrong, fine.
Exactly.
If it's evolving law, or if it's something which will need to be addressed because you all agree value's got to be scrapped over, something which has to be addressed later, maybe that's different.
My Lord, if there was a debate about what the economic value was, so if they had asked themselves the right question, then of course that would not be a matter for certification, it wouldn't be a basis to oppose the amendment. But what we say they do have to do is put together a case which is framed in the correct way. I mean, if one was looking at this outside, for example, the context of a collective action, it doesn't actually matter with respect that this happens to be a collective action. This is an amendment application.
Yes.
And what we're saying is, assume everything they say is correct. All of these points, which we hotly contested, obviously, but let's assume they succeed on the allegations about economic value post-2014. We say that case would still fall over at trial because they have not addressed the right question.
You say that, if you look at 253, she distinguishes between various things, and 254, she says it's useful to distinguish between various things. But if you actually look at what she says she's doing, it's not the first part of 261, but the second part, but to assess whether Facebook has struck a fair bargain as it has increased data extraction over time. I understand it's clunky wording, but if that's what she's doing, that doesn't necessarily exclude consideration of the value at the early part as well as the change in value over time. I don't, at the moment, necessarily accept that she's done what you say she's done. You understand my problem?
Well, I just need to come back to the, if I may.
Well, why don't you take it in order? And because sometimes we need to see how it develops organically.
Yes, I understand the point, but the answer is, theoretically, one could separate out economic value and look at different parts. I understand that, but with respect, when I take you through the report as a whole...
Why don't you do that? We jumped in the middle, or possibly the end. So
no, it's helpful, because that is
when people say that, we never believe them. When someone says it's helpful, we know you don't really.
Well, if I could put it this way, I do intend, and I had intended to spend a lot of time going through the report, because in my respectful submission...
You do that.
But can I just quickly introduce... I'm actually going to show you the claim form and then the expert report, but can I perhaps just quickly introduce ground 2. Ground 2 is different, but we say also raises a point of law. Now, ground 2 concerns the second abuse, which is alleged, which is the alleged unfair trading condition. And what's said in that respect is that Meta abused its dominant position, the alleged dominant position, by requiring Facebook users to consent to the collection of off-Facebook data.
Yes.
And they describe it as a take-it-or-leave-it condition.
Yeah.
And this is a short but important point, because the primary case is that they will succeed on proving both abuses, the unfair price and the unfair trading condition. And what they say is in the counterfactual, Professor Scott Morton has a model which shows...
Nash model.
Exactly. They say there would have been this theoretical bargain, a payment of value to users. Now, the difficulty arises because the infringements are pleaded as self-standing infringements. And the tribunal...
And/or, I think, aren't they?
Exactly. Further
but they're cumulative as well as alternative.
Exactly, my lord. And so we accept that if they make good both abuses, they have pleaded a counterfactual supported by a methodology. And for present purposes, we're not taking issue with any of that. But our point under ground 2 is what if the class representative only succeeds on the unfair trading condition? So they're distinct. At least in one scenario, there's a case being advanced which is the only abuse on this hypothesis would be the take-it-or-leave-it condition. And we say, on a proper analysis, they actually haven't pleaded a complete cause of action, because the counterfactual which they have pleaded and the model on which the pleading is based is entirely dependent on proving both abuses. It's all about establishing what they say would be...
So if they can't show it's an unfair price, in terms of damages, it makes no odds that they can show that the term was unfair.
Or at least, even before it makes no odds, they haven't even begun to articulate a chain of causation. What's the causation? What's the loss if you succeed on that abuse?
Only on the TOLE point.
Exactly, as some of us refer to it. Yes, exactly. Yes. Exactly. And that, my lord, isn't a point of law, but it's not the technical pleading point. It's actually a substantive deficiency. You can't advance distinct infringements and then only advance a counterfactual.
But it must assume that you fail on the financial point. If you fail on the money point, then what? I mean, you may get a declaration. It wouldn't get you very far, possibly.
Well, that's what we're saying is at the moment in Cohate. So the pleading says you've abused your alleged dominant position in two ways, and if they prove, but we say, well, what's the chain of causation? How do you get? And what they say, there are various assertions in the papers of, well, the model works in that scenario too, and that, with respect, is actually a completely false point, because they are fundamentally different types of abuses. Once you start, I think, as your lordship's got the point, if the hypothesis here is the price is fair, so they failed on their unfair price allegation, then there's no question of needing to change the value.
Well, there's just no damages if the price is fair. They wouldn't, in the counterfactual, be any different. Sum of money being paid.
they wouldn't need the opportunity to negotiate a fair price with the problem.
Exactly.
Your point.
And all of these points...
Then ground one. Okay, I mean, I see the point. I mean, it's quite a narrow point.
It's a narrow point, that's why I say it's a short point, but it is an important point because the tribunal, we say, has erred in accepting that they are pleaded as self-standing infringements, but not grappling at all with whether they've actually developed a chain of causation.
Okay, let's assume in theory you're right, but then the tribunal effectively says, you know, granted, on ground two, the CR will lose, but that's really a matter for trial because one of the things we've got to grapple with is whether, as they say, they're two sides of the same coin, they're really different ways of looking at the same thing, and really it's all about a renegotiation in a financial context. And I don't think they're really saying that if they lose on the money aspect of the claim, there's really a serious benefit to winning at trial.
Well, my lord, they are advancing the case on the basis that the model put forward by Professor Scott Morton, they say, can be adapted to a scenario where they win only on unfair trading terms. Of course, if they turn around and say, we accept your right, which we plainly are in my submission, there is nothing that follows if we only succeed on the unfair trading condition, then we wouldn't need to be here. But for as long as they're pursuing that case, and for as long as the tribunal has endorsed that case, we're entitled to say there's an error of law, they've done no work on that.
We understand the point.
So, my lord, that's why, for today's purposes, the meat of it is the unfair price, because that's going to take me a bit of time to explain the claim form first and then the expert report. But ground two, we do submit. One shouldn't lose sight of that, even if I spend less time on it. Now, could I start with the amended claim form, which is a supplemental bundle tab 2?
I'm just thinking through questions of timing. Can you aim to finish between 5 and 10 past, giving Mr. Donoghue a reasonable amount of time to respond, and then you have a chance for a reply?
Yes, of course. I will still probably take the claim form and expert report relatively slowly, but then I can make the submissions. Your lordships clearly have the point.
Yeah.
I'll take the submissions.
We want to see how the argument builds up.
Yes.
So, okay, let's get cracking.
So the claim form. Could I start with paragraph 7?
Just give me the reference.
Sorry, supplemental bundle 2.
Yep, got it. Yep,
Page 61.
Yep.
And so one can see here the summary of the case. The claim concerns the off-Facebook data only, and the off-Facebook data, you see it towards the end, these data were then combined with the data that Facebook collects on platform.
Yep.
And monetized by Facebook without a corresponding value transfer. So the point here is that they accept, as they have to, that this off-Facebook data is only part of the story. It's combined with the on-platform data. Then at paragraph 8, you'll see they describe this as an unfair bargain. So the collection of off-Facebook data. So we've already essentially left the on-platform data out of account. Their case is confined to the collection of off-Facebook data as a condition of access. They call it an unfair bargain, and it can be looked at in two related ways. So the first is the take it or leave it offer, and the 8B is further or alternatively, which is the point about distinct infringements, unfair price within the meaning of United Brands' line of case law, adapted to the particular circumstances of the present case. And just pausing there, for the avoidance of any doubt, we do accept that in certain respects, the novelty of the case, the fact that it's to do with data and a zero monetary price and so on, we accept all of that may be within the realms of adapting or adaptation of United Brands. But we are on a different point, which is whether they've aimed at the right target. Paragraph 37.
But they do keep saying in B, I mean, I understand your point that what they're saying is the thing that really upsets them is this new off-Facebook data that's not being paid for. But they do say it's unfair to provide the social networking services without giving any payment for that. If they put in the words to provide the service without any payment for that element of it, it would have been fine, wouldn't it?
I'm sorry, Michael, can I just ask, where are you?
Oh, it's 8B.
Yes.
Facebook demands an unfairly high and abusive price or payment in kind for the provision of social networking services. So it's there that you've got to look at what's being provided as networking services, and it's going too far, they say. It's a bit off iffy if you don't give anything more than for the off-book data. It's necessary that they're aware that the thing that they're getting is the service. You're going to have to value that somehow. And the thing that tips the balance, they say, is a new thing.
Yeah, my lord, you're right that that's what they say.
Yes.
The thing that tips the balance. But our point, and this comes out much more clearly if you just take it through.
On, okay.
But my lord, conceptually, I understand the point your lordship's making.
Yeah.
But if I could just perhaps at this point just make this analogy. In a pharmaceutical case, where often these unfair pricing competition cases arise in the pharmaceutical context, one doesn't look at a particular increase in the price at a particular point in time and say, well, at that point in time, did you increase the price by X, and does X match any increase in the economic value of the pharmaceutical product? It's just simply not how the case law is.
But it can be. It's not necessarily the only way of proving excess. I mean, it's never been said that's not an invalid way. In Flynn Pharma, we simply said there are lots and lots of different ways of establishing unfair pricing.
And data might be different.
Well, I'll come back. My lord, it's not, with respect, the cases all look at whether the price, full stop, is unfair. And what is looked, in terms of economic value, one looks at the product. What's the patented or generic pharmaceutical product worth to the user?
Yep.
Now, what they are doing here is they're focusing only on an incremental increase in the price. And they're saying, well, did you correspondingly increase the economic value? Now, we say that it's wrong to completely leave out of account all other elements of what's said to be the price and all other elements of pre-existing economic value. That's the key distinction. They're assuming that well, let me come back to that. But that's the helpful, I hope helpful analogy.
Yes, okay.
One can draw. So 37 at page 70.
Yes.
This is throughout the claim period, the social network service was offered free to consumers. Then they say, however, users have to agree to various terms, as explained in more detail below. These included giving Facebook permission to collect and otherwise process users' personal data, both on and off platform. So it's recognised there that in terms of the data that's being provided, which they describe and their expert describes as the consideration for the bargain, it's on and off platform data. And yet the case goes on to describe the relevant price for their purposes as being only the off Facebook data. So they're leaving out of account the on platform data. And then at 95, which is page 101, a reference to Facebook ramping up the volume of data that it collects over time. And this is where one sees that their focus is the off-Facebook data in the period post-June 2014. And then if I could ask you to look at 96, page 109. So United Brands and so on comes up later in the claim form, but this is actually a helpful paragraph to demonstrate the nub of the case. In contrast to the ramping up of the amount of off-Facebook data, they haven't made commensurate or related improvements to the service they provide to users, which reflects the increased extraction of off-Facebook data. The key user-facing functionalities were already in place prior to the introduction of off-Facebook data by around June 2014. And my Lord Justice Lewis asks, well, in theory, could one look at value post and pre? The key point when we get to the expert methodology is there is no attempt to value those user-facing functionalities which they accept were already in place. In other words, this bargain that they describe between Facebook and users has been in existence for a lot longer than since June 2014, and yet they leave all of the prior period out of account, both in terms of price and economic value.
So they assume that after 2014 there was no incremental value to the user through Facebook. you say that there was some, and it either captured the entirety or the preponderant part of the consideration, namely the extra data.
Well, my lord, we would say that as an alternative, we would take issue with the extent of economic value post 2014. So they say there was none, and we say that there was
total.
Yeah, but that's a question for trial, like I said.
Yes.
That's a debate about an evidential debate about the economic value post 2014. The point of law arises, and again, one will see this through the papers. The point of law arises because there is no attempt whatsoever by the claimant here to value the Facebook service to users pre-2014. So anything that was already of value to Facebook users before off-Facebook data tracking started is being omitted entirely from the analysis. That's why, my lord, the debate that we will inevitably have about economic value post, that will be our fallback position. Our primary position, which is the point of law that we're pursuing at this stage, is that's not the right battlefield. Let me continue.
Well, you have to explain to me why that's a point of law as opposed to simply a difference in the approach you're both going to take to the evidence.
Because, my lord, it's not merely a contest as to, it's not merely a case of an evidential dispute as to, well, what was the economic value? We say lots, they say zero. It's not that kind of debate. At this stage, my lord, the issue is that a claimant here is not entitled to put their unfair pricing case in a way that focuses only on an incremental aspect of what they say is the price and an incremental aspect of the value. I mean, to put it bluntly...
And just to be absolutely clear, when you use the expression incremental, you're effectively saying you treat everything pre-2014 as zero.
Exactly. To put it bluntly, a Facebook user uses a Facebook service. So if one is looking, in line with the case law in the United Brands jurisdiction, at the economic value of the product or service, the question is, well, what is the value of the Facebook service? In my submission, it's actually a very straightforward point that you cannot, within the United Brands jurisdiction, measure the economic value of something less than the full product or service, which is what's going on. They're saying, well, ignore the fact that they're huge, potentially huge or potentially little. They could say, before 2014, there was no economic value. We've done it. Yeah,
I'm not certain if the case does assume there's zero economic value.
It does, my lord.
It's just simply saying that the value after 2014 hasn't been accounted for by way of extra payment value negotiating capacity to the user, whatever that pre-existing value was. We may accept there has to be there may be some incremental value to the service from off Facebook data, but there's I'm still trying to get my head around why this is law,
yes, because,
not just a question of fact.
Because all of the cases, my lord, one sees this completely consistently through the cases. The question that's being asked is the economic value of the product or the service. And then there's a debate about how does one measure it, was it lots, was it little, and so on. Here we do have a point of law. The point of law is whether, in all of those cases, where there is reference to the economic value of the product supplied, it tends to be the language that one sees in the cases, whether the product supplied means the actual product supplied, here the Facebook service, or some discrete aspect of the product or service supplied.
I understand that 96 is your best paragraph for that.
Well, so far, my lord.
So far, you've got others, but at the end of the day, it's one paragraph in a mass of, some might say, totally unnecessary detail. And if you go back to 8B, I think it was, there's no doubt that they're aware there's the provision for the service, and they seem to assume that the service was exactly valued by free access to Facebook. And it might have been they were getting it cheap, and they should be paying a bit more. Whether they should be paying as much more is another question.
I think the point I'm making, which is that there is no attempt to value, indeed an express statement that she will not look at the aggregate value, of the Facebook service. This comes out much more clearly in the expert report, which I'll come to in just a few moments. But can I make this point, which is actually quite important to understand? If one takes a step back, why are they doing it in this way? Why are they doing it in this, we say, legally impermissible way? The answer, and Professor Scott Morton herself refers to some of the literature on this, the answer is that if one actually did a proper analysis of the economic value of the product supplied, namely the Facebook service, to users, the literature shows that users attach huge value to the service. And so if they were to try and do a conventional United Brands assessment, one would find actually real difficulty in trying to show that there was no reasonable relationship. So they've actually, in my submission, one can infer they've taken a deliberate decision to frame their case in what is actually a self-serving way, because what they're doing is they're saying, well, forget about all of the economic value, the huge economic value that accrues to users before you started off Facebook data tracking. And we'll just focus on whether you were entitled to increase the price in that limited way, and did you have corresponding value, confer corresponding value on users when you took that decision to start collating off Facebook data. So there is a reason, a forensic reason, why they've chosen this approach, but we say there's not a single authority where the product supplied, where something short of the actual product being supplied is being valued.
The same might be said of a patented drug, which is crucial to the survival rate of a patient, valued enormously highly by the patient and almost by derivation by the NHS. It doesn't mean to say that it's being charged at a reasonable and fair price. I mean, I understand the point you're making, and yeah. I can, without having heard any evidence or analysis, can see that plainly value has a role to play when users attach a very high premium value to a service. There may be all sorts of arguments which go to that, and it may be that some consideration going from the user over and above the on-Facebook data would need to be factored in, but I mean, still trying to work out whether this is fact or law.
Because, my lord, it's not for, well, first of all, they're not actually assuming it's zero. They're not even looking at the question. They're just not turning their minds to the question of what was the bargain. They call it a bargain between users and Facebook. They're beginning the inquiry at
halfway down the line.
Exactly.
Okay, well, what we want from you then is the paragraphs that you're going to come to, which we keep on preventing you from getting to, which...
Well, 96 is your best so far.
Well, no, that's just one reference in the claim form, but actually, when I show you the later passages in the claim form, one sees, it's actually just to show that the claim form, other than hints in 96 of this incremental approach, let me just quickly show you how little there is on economic value in the claim form itself. And perhaps I can just, in the interest of time, just jump ahead to, say, 150, which is on page 151. You see a section introducing the abuses, two related ways in practice amounting to the same thing. And then at 152...
Sorry, I'm just catching up. What do you draw from 150?
Well, 150 is just a reference to, they keep describing the two abuses as in practice amounting to the same thing. And that's relevant actually to ground 2 on the counterfactual. One actually needs to be very careful to separate them out. But on the unfair price, if one looks at paragraph 153...
You again have to look at the last sentence of 150 in both cases. The government is the unfair bargain or barter Facebook made with users, and that must be the bargain, not just the bargain in relation to the extra bit. But anyway, you want us to look at 153?
153, you see that 153A.
153. I've got it, yeah.
Whilst the provision of the service does involve users notionally paying a zero price, there is valuable consideration flowing from users that has economic value.
Sorry. I'm just 153.
So 153 is the main paragraph in the pleading. It's very long, and actually, I'm about to show you it's very confused.
Sorry, 153. I've got 8. It's
161 of the bundle.
Yes, I've got there. You say there's a lot. A, B, C, D, E, F.
Exactly.
Which bit are we on?
So I'm just showing you A. So I'm showing you that they accept United Brand supplies, and then they're saying in A, and also we'll see in a moment in subparagraph E, in the claim form, it's all very confused because the way it's put is that they're actually looking at the economic value of the off-Facebook data to Facebook. It's actually Meta, but they say Facebook. So they're actually in the pleading not even asking the right question because they're asking the question in the opposite direction. So this is actually pretty unhelpful, but I'll show you when the expert does at least look at the position in the right way. So in the pleading at A and E, in E they describe the overarching concept as a price that bears no reasonable relationship to economic value. And then they go on to refer to the economic value of the data to Facebook. And as I say, that's not even asking the question in the right direction. But at least they accept that economic value is the overarching concept. So there is common ground to that degree.
This is in E, 168.
153, my lord. I think page 168. Yes.
That's right. Yes.
So what's the objection to E?
Well, E, the objection is it's not even asking the right question because it's asking the question from the perspective of the value of the Facebook data, the off-Facebook data, to Facebook, when actually the substance of the position is that it's users paying for the Facebook service.
But just reading it, as somebody who's not primarily a competition lawyer, the overarching concept is a price that bears no relationship to economic value. It is also relevant, not saying the definition or only thing that we look at, it's also relevant when considering the fairness, to consider the economic value that Facebook derives from monitoring users off book. So they know there's a broader economic value, but they're saying it's all right as we go along in this business to have a quick look at the facts relating to the Facebook data. They're not saying that's the thing that's the economic value, are they?
Well, with respect, my lord, they aren't nowhere in this very long pleading does one see a plea as to the economic value of the whole Facebook service.
They certainly don't tell you what it is. I see that.
Or make any allegations as to it, my lord. That's the point. I mean, this is the claim form. They need to make an allegation. They make an allegation of an unfair price. They say in the claim form the consideration is user data, on-platform data and off-Facebook data. They accept economic value as the overarching concept, but they never, in this...
ascribe a value to it.
Or, no, my lord, it's more than that. They never allege that the economic value of the entire Facebook service to users... Well, let me start that again. What they should be alleging, as a matter of law, for this to fit the legal framework, the allegation has to be that the price, and they themselves describe the price, and their expert describes the price as all of the data. She actually says it's data and attention, but data appears on platform data and off Facebook data. What they need to be alleging is that the price is all of that data, and that price bore no reasonable relationship to the economic value of the Facebook service as a whole. Now, if they advanced a case in that way, there would be no point of law, or the point of law that I'm advancing wouldn't arise. I completely accept that. You would then be into a straight evidential fight at trial as to have they defined the so-called price correctly, have they assessed the value properly. But they don't make any allegation to that effect. And then one sees the expert report, and in these collective proceedings, the expert report is intimately bound up with the pleading. There is no attempt to address that question. Let me jump straight now to the expert report. We pick this up at it's supplemental bundle tab 3. And could I first show you paragraph 72 on page 225?
The CAT has sort of signposted some of these difficulties in its judgment. and yet it decided when it actually got to the pith and substance, it sort of knew what the claimant was saying. I mean, it had some sympathy with the criticisms you're making, but it didn't actually think at base these were showstoppers. I mean, it sort of nudged case management it was engaged in, basically hinting, you're going to have to clarify some of these points in due course. Was it wrong to do that?
It was. The CAT's reasoning is problematic in a number of respects. I'm hoping to get to the judgment, but essentially it's problematic because, first of all, it says, and we agree, that generally speaking, one measures the entire price against the entire product. We say that they actually were wrong to say only generally speaking. We say it's exclusively under the case law. One sees a comparison of the full price versus the full product. The other point where they erred is that they failed properly to understand the methodology. So they assert that she does look at the economic value of the entire Facebook service.
It would be really helpful right at the end if you can just give us bang, bang, bang bullet points
Yes,
why the CAT got it wrong.
Yeah.
For example, your focus on the word generally there is important.
Exactly. I'm hoping to come to a closer analysis of the judgment. But let me quickly show you, because my Lord, one of the points that the CAT does say is we've got it wrong. She does look at the economic value of the full service. And so I need to show you why that's wrong. At 72, this is instructive because one can see here, whilst Facebook is free of charge to users from a monetary point of view, it's my view that users are still paying an implicit price. Users must give up their data and be exposed to advertisements. There, she, the expert, is defining the relevant price.
You criticise that?
No, my Lord. No. I'm simply saying that she accepts, and she characterises the bargain as being all of the data. And you'll see ones at 77 and 79. There are all three different categories of data that she sets out. So this is just helpful in showing that when they come to the core United Brands analysis, it's an artificial price which they use. And then if one looks at section 4, which is the section considering abuse, it starts at page 255 of the bundle. And could I ask you to look at 194, penultimate sentence. Well, actually, no, let me take this more slowly, because this is an important paragraph. She says, ultimately, from an economic perspective, the abusive conduct to be analysed is the...
Sorry, where are you reading from?
194, second sentence.
Second sentence, yes.
It's the striking of an unfair bargain. And then the next sentence, it's a bargain in which users provide their attention and data in return for the access to the services. And then penultimate sentence, as a price for access to this personal social network, Facebook requires users to agree to off-Facebook data tracking on a take-it-or-leave-it basis and without providing adequate compensation. So again, this is important because she herself is defining the so-called bargain between users and Meta as involving all of this data and attention.
But you agree with that, don't you?
Well, what we say is if you characterise the bargain in that way, that should be your relevant price for United Brands.
That's the economic value you're trying to assess.
Exactly.
Do you agree with it then?
No, my lord. We're on the price side of the equation here. What she goes on to do is look only at the off-Facebook data and treats that as the relevant price.
So you say there's an inconsistency. Here in 194, she, as it were, gets it right, but then she wrongly narrows it down and treats the off-Facebook data as the only value.
Exactly. Exactly so, my lord. That's the point. Because we say on both sides of the equation, they are salami slicing inappropriately. They're taking an artificial price and comparing that against the economic value of an artificial product. I'm going to skip over the parts of the report I was going to show you.
So do you want to just take us to a paragraph where she only treats off-Facebook data as relevant value, just so we've got the distinction clear? You don't have to take us through everything.
That is the only thing that you can use to assess economic value. That's what we're looking for. It's a paragraph that says, I can and have to disregard any value other than...
It's section... I need to show you section 4.5 for your Lordship's note. I'm going to come to that in a second, but that's the critical section. But let me, before I should take you there, show you 4.4. So if your Lordship looks at page 262 of the bundle.
Yep.
And we're now within limb 2, unfairness, and you'll see at subparagraph D, she's going to look at the extent to which the value generated by off-Facebook tracking accrued to Facebook or users. See that? So that's just looking at value generated by off-Facebook tracking. And then if I could ask you...
Well, she looks at a lot of things for a preliminary analysis, including E is a bit... You can't just take D out of context. No, anyway, it doesn't matter.
Well, no, my Lord, it does matter, because the point I'm making is what one doesn't see anyway. I mean, she is looking at a lot of things, and I'm not suggesting otherwise. I'm simply saying that what she should be looking at is the value generated by the Facebook service as a whole.
Yes, I agree with that, but this is a preliminary analysis of quantitative and qualitative evidence. It's not the legal test that she said she's applying, but it doesn't matter.
Give us the paragraphs you say are relevant, and then we can...
236, my Lord, on page 265.
236.
This is where she develops the point in subparagraph D. So it's 236 to 238. Now these paragraphs tee up, in my submission, what comes in section 4.5, because she's narrowed the question to the value of off-Facebook tracking. And she says, my preliminary assessment is a much larger proportion of the benefits have accrued to Facebook than to users. And then in 237, her assessment is the key user-facing functionalities were already in place prior to the rollout of off-Facebook tracking. And in 238, she says the only major consumer-facing features I'm aware have been added since 2014 are, and she goes on to list them. And then we get to the main section on this, 4.5. And I need to take this in stages. So she says, I understand the case law, this is 252. Understand the case law on excessive pricing allows for prices that reasonably reflect the economic value of a product, well, we agree. To conduct my assessment of whether Facebook creates economic value to users, I consider it useful to decompose the value of Facebook into different components. So far, we have no objection with this. And then she breaks it out into, we've looked at this paragraph, 1, 2, and 3. And just so you have the submission, what follows is an attempt only to attribute or assign economic value to 3.
You say what follows is only an attempt to value little Roman 3. When you are referring to what follows, which paragraphs do you mean?
My Lord, it's the entirety of section 4.5.
255 onwards?
Yes, through to really the end of this section, which is 281. I appreciate time's short, but I do need to take these paragraphs slowly because it's very easy to misunderstand the approach that's being taken because these materials are so voluminous. But actually, when one looks at this carefully, you can see, so 255, she is referring to an argument by Facebook to the effect that its conduct was not abusive because users receive significant consumer surplus from using Facebook. So that's the service as a whole. And then she refers to Meta's expert at 256. And she says at 257, the point I foreshadowed earlier, that various studies do indeed show that consumers value Facebook, that's the whole service, significantly. And then she says, and this is very important, I do not think that a comparison between this value and the cost of giving up the off-Facebook data is the right way to assess the fairness of Facebook's conduct. And then you'll see first, second, and third, and then again, a very important paragraph, 261.
Yes.
And my Lord, Lord Justice Green's asked a couple of times, why is this a point of law? And really it's crystallised in 261. She has taken the view that the right approach to assess the fairness, and we're within a section on economic value, we're within the United Brands framework, which she says applies, but she will not look at the aggregate value of Facebook to users. But instead, she says the right approach is to assess whether Facebook has struck a fair bargain as it has increased its data extraction over time.
So it boils down to this. This is what she says is her view as a matter of fact, evidence and economics. You say that that's wrong in law. And if you're right, then her approach is defective in law.
Correct.
Alternatively, this is simply her approach to the evidence under the broad concept of what's value. You're entitled to put forward an entirely different case, and the CAT will have to decide whether you're right or they're right.
But my Lord, we're not yet at the stage where we're having a debate about the economic value. We're actually having, as I say...
Well, no, it's her approach to value.
It's the approach to the United Brands framework. We're saying she is not entitled as a matter of law, and I do stress this, there is not a single authority, my Lord. One doesn't see this in any of the cases, nor in any of the CMA administrative decisions or the decisions of the Commission, where one sees a rejection of looking at aggregate value of the product supplied.
Is it that black and white? It's not just that, she says, but to assess whether it struck a fair bargain. And I'm still not sure that the bargain can mean the bargain only from 2014 onwards, but is the whole bargain from access at the beginning and the changes in 2014, and she thinks what happened in 2014 tips the balance considerably.
Correct.
It might have been fair before, but after 2014, hold on a moment, they're getting squillions, and the users aren't getting anything. And she said, hold on a moment, that's now moved out into a different thing. Is that really ignoring the initial value, or simply saying, if you like to use the language, dwarfed by what has happened later?
Well, my Lord,
I bought an ice cream, and now they've taken the whole truck away from you. It's a bad example, but you know what I mean.
my Lord, the first sentence of 261, in my respectful submission, could not be any clearer. Having rejected an argument by Facebook that one needs to look at the consumer surplus from the service as a whole, she then says, my view is the right approach is not to look at the aggregate value. And you're absolutely right. You've accurately summarised the way in which she's going about things. She's looking at whether there was a fair bargain over time from 2014 onwards. But that's what we describe as the incremental approach. That's not action. Okay. I've shown you earlier paragraphs.
Okay, we've got the point. We understand it. There may be no need to take us to lots. Once we've got the point, there's no need to go through the expert's report at great length, because there'll be paragraphs which perhaps swing one way or another. I've got the point. I understand it. Is there law that you want to show us which will actually support? I mean, you know, we are sort of trying, we've got an arguability threshold. If you've got a point and you're on the cusp of something which is arguable, you probably get the benefit of the doubt. But how much more do you really need to show us?
Well, given some of the questions from my Lord Justice Lewis, can I just finish on section 4.5?
Yes.
Because this is it's a combination. I will show you some case law, my Lord. Yeah. And I do respectfully submit there is a point of law, but the point of law I do accept only arises once one's actually understood what's going on. That's why it's important. Let me very quickly show you. I've shown you 261, and then 265 to 268. You'll see again a continuation of the incremental approach. What she's asking...
The heading as well, I mean, what she's saying is it could have been justified by this. She's looking to see if that was an explanation.
But my Lord, if I could just show you the first sentence of 265. In my preliminary analysis, an increase in data extraction by off-Facebook tracking could in theory be justified on the basis of Facebook introducing new services, but while not directly linked, were introduced contemporaneously. Again, the only thing that in her view would count as economic value would be new services introduced contemporaneously. That's again reinforcing my point that she's disregarding any economic value that accrued prior to the 2014.
Okay. I see it. I mean, it may just be said she started with the assumption that there was fair value up to 2014, which is attributing value. But I see the point.
Well, in the interest of time, can I perhaps just so 269
Yes.
is also an important paragraph. Finally, in my preliminary analysis, the off-Facebook data is not directly used to improve the service to users. Again, what that reveals is the only thing that she would count as valid economic value is some use of the off-Facebook data to improve the service. But what about all of the value of the service prior to that? And I just perhaps finally just show you 280. I would hope, obviously, at a main appeal hearing to take these points more slowly. But just to really close off on this idea that she's clearly adopting an incremental approach and only an incremental approach. That's confirmed in paragraph 280, the end of this section. She says, I conclude there's at least a prima facie case that the economic consequence of Facebook's extraction of off-Facebook data without a corresponding value transfer to users amounts to an unfair bargain. My assessment is this unfair bargain. And so you'll see that what she's looking for, and what the case is looking for, the allegation is about the value transfer, whether there was an adequate value transfer in return for the off-Facebook data.
We need to read 281 as well, don't we?
Yes, but in my submission, 281 doesn't really advance matters on the incremental approach. I mean, my learned friend said...
Do you accept that she seems to implicitly assume that as of 2014 the bargain was fair?
Well, the CAT in its judgment referred to an analysis which it calls the cusp analysis. So one could construct a case along the lines of saying, well, the bargain was on the cusp of an abuse, and then you tipped it over the edge by some change that you made. And that's the sort of thing which the CAT had in mind. But the difficulty with that is that's not the case that's being put here either, because there's no attempt. If one was trying to construct a case and put the case in that way, one would need to measure the bargain before the change. One can't make any assumptions. If one wants to focus in on a particular price increase at a particular point in time, one actually can only do that if one's already had regard to what was going on before. And that's the fundamental defect. There's no attempt at all in any of the claim form or the expert methodology to engage with the position. There's no assessment of what she describes as the bargain. So therefore, you're not entitled, as it were, to start in 2014 and start with off-Facebook data tracking without having conducted any analysis or even making any allegations. As I say, what they need to do is plead something about the whole bargain. She's characterised herself, the bargain, as being all data and attention by users in return for the full service.
Yep.
So that's what I wanted to bring out from the report on ground one.
Yep.
And then in terms of law, as I said, there's not a single authority which supports this approach. And perhaps I should just take your lordship to the Flynn Farmer decision. But before I do, the other case, actually maybe I should show you At the Races, just very quickly, which I know was considered in Flynn Farmer. But that's at Authorities tab 3. At the Races was a case where there was an appeal, a point of law therefore, on this question of what economic value meant. And the Court of Appeal said that the judge had erred in regarding economic value as meaning only cost plus. And the court said, no, you have to take into account also demand side value. And just to quickly show you the references. So paragraph 117. This is Lord Justice Montgomery saying the central concept is, your lordship have that?
Yes. And
it's the economic value of the product supplied. And that phrase, economic value of the product supplied, comes straight from United Brands, which is quoted at 114. And our basic point is that product supplied there means the full product. Here, the full Facebook service. And then at 152,
Page 152 or 152 of this judgment.
Sorry, my lord, paragraph 152.
You just need to have it.
we don't have that. Interestingly, we go from 119 to 204 on page 116. maybe something wrong with the
Yes,
transcript in the business law.
there was an update to the authorities bundles that clearly that hasn't made
Oh,
it.
well, maybe.
Shall I?
Well, don't worry about that. Just tell us what's in the paragraph.
Yes, well,
I can check it afterwards.
I can just say 152. As to the law, the parties were agreed that United Brands applied, and then they say, as laid down in United Brands, a test is whether the price is excessive because it has no reasonable relation to the economic value of the products. But same point.
Yeah.
But product supplied, we say means the full product, and at 230, I was going to show you 213 because there, Mr. Roth, who was the appellant in arguing the case for the appellant in that case, the court there noted that he accepted that there's no single methodology or litmus test of abuse. The court has a choice of methods, but not an unlimited one. And his contention was the judge had gone outside the admissible limits of method in coming to his conclusion. And that's similar to a point that arises here, because whilst we accept there's flexibility, there are limits. And one's not talking here about methodology as actually what is the correct target. And so in At the Races, we rely upon that for a couple of things. One, product supplied means product supplied, the full data. Two, there was a point of law on economic value which justified a full appeal. And three, simply saying, as no doubt Mr. O'Donoghue will, United Brands is flexible. Well, that only takes you so far. It's flexible within the correct framework. There may be flexibility as regards the evidence and so on.
Yeah.
And then if I can show you Flynn Farmer, and I should say none of the cases expressly deal with the point that arises here, because in my submission they all proceed implicitly on the basis that what one has to value is the full product. At 59 of Flynn Farmer.
Sorry, which tab?
Sorry, Mark, what's the next tab? Tab 4?
Tab 4. Yep, thanks.
And at 59 to 63, my Lord Justice Green starts a discussion about United Brands. Mm-hmm. And at 59, paragraphs have three components: legal test, what this means in economic terms, and then methods and evidence. And then you describe at 61 the two central economic features, and you can see them 1 and 2. And then you say at the end of 61 that you come back to the concept of economic value in relation to the fourth round of appeal.
Yep.
But then, my Lord, what's important here is you go on at 62 and 63 to refer to the references to methodology. And you say at the end of 63, there should be no suggestion that the United Brands test should be construed as if it set down a fixed and definitive methodology. And again, to be clear, we accept that. But methodology only arises within the framework. And what we say is they are misapplying the underlying economic value concept. And this
I doubt there's any challenge to the proposition that there are limits, even if there's flexibility within those limits.
Yes, and we say we're at the very first stage of defining, well, when you are engaging in an economic value inquiry, what is it you should be looking at?
Yep.
And one sees this at 153 and 4, paragraphs 153 and 4.
Of Flynn Farmer?
Of Flynn Farmer, yes. There's a discussion here about economic value, and you say at 154 the concept of economic value is not defined, and then in broad terms it's the economic value of a good or service is what a consumer is willing to pay for it, but that can't be an adequate definition, obviously.
Yeah.
And then you say at the end of 154, to overcome this, the court held there must be a reasonable relationship between price and economic value.
Yeah.
And our point is, and the point that we would wish to argue on at a full hearing,
yes,
all of this is proceeding on the basis that it's a reasonable relationship between the actual price paid and the economic value of the actual product supplied in return. I mean, in one sense, if I can say this, it's so obvious that it actually goes unstated in all of these cases. And it's no good, we say, to rely on the novelty of this case in terms of concerning data and so on, because the test is still the test. And then at 171, 1, paragraph 171 and 172,
Yeah.
Your Lordship says that the tribunal was wrong to identify economic value as a separate component of the test. It needs to be taken into account at some part of the analysis. And again, if one looks at 172, Your Lordship says the tribunal didn't agree, and then you say you agree with the parties. It's evidence that it's reference to economic value as part of the overall descriptor of the abuse. It's not the test. But the test should therefore, when properly be applied, be capable of evaluating economic value. And then you go on to say there's no need to double count. But at the end, you say, in short, economic value needs to be factored in and fairly evaluated somewhere, but it's properly a matter which falls to the judgment of the competition authority. Now, just again, to be completely clear, we're not having a debate here. It's not a situation where we simply disagree about the way in which they've arrived at economic value. We are saying that they are not measuring the economic value of the correct product.
Your case is that when you read the references you've shown us, they are deliberately saying you do not exclude it. That's what you say we should read those paragraphs as meaning.
Correct.
Do not.
And more than that, my lord, we would say it's not for us to come along at trial and say, well, what about all of this economic value of the service that was accruing to users before 2014? In my submission, that would be taking matters the wrong way round. They are applying for permission to amend. They need to satisfy the arguability test. And as I say, if everything they say were accepted at trial, we would still be saying it's wrong as a matter of law.
Okay, I think we've got the point. I think we know what the relevant references are. We understand the relevant framework. What do you now need to do?
Can I show you the cat's judgment, just to explain why we say
Yes, you can take that pretty briefly because we've read it and considered it. But do give us, I'd like to know what, to really identify on the paragraphs where you say the error is manifest.
Yes, of course. So the judgment is in, I'm sure you have it, four bundle. And the critical paragraph is 25, subparagraph 2 on page 63.
Just 1 second, let me just get the judgment. So 25
subparagraph 2. So, does Your Lordship have that?
Yes.
Roman 1, United Brands test is a flexible one. We say yes, but it has limits. Then they say in Roman...
I'm not with you now.
Oh, I'm sorry, Manuel.
I've got Roman 1. I don't understand why competition law. It's like reading a catechism. Is it big 2 on 116?
It's big 2 Roman 1, Manuel.
Oh, big 2 Roman 1. Okay.
At the bottom of the page.
Yeah,
United Brands test is a flexible one, and we say, well, that doesn't justify applying the wrong framework. Then they say in Roman 2, generally speaking, both excess and unfairness are assessed by considering the overall price charged for a service offered by a dominant undertaking in light of the totality of the service provided. And we say they were wrong, in fact, to say only generally. The position is exclusively. And one will see there's not a single case here cited in support of the proposition that there may be exceptions to the rule. And then they say a dominant undertaking is in the same paragraph. A dominant undertaking is entitled, sorry, I should start from comparables are extremely important in assessing abuse. Incremental increases of price in respect of an existing service that doesn't change are not even presumptively unlawful. A dominant undertaking is entitled to increase price without improving the quality or quantity of its offering.
You agree with that?
Exactly, my lord.
And the next bit? In other words, shouldn't disregard them because they're relevant. So it's not in and of itself that increasing the price is unlawful, but it's not irrelevant. Because that's what I anticipate is going to be said against you, that they agree with all of that, but it's the latter couple of lines which they say they're focusing upon.
It's the shift may make an overall bargain which at one stage was fair, unfair. It's not you're valuing the shift. It's the shift that means you recalculate the whole overall bargain.
Exactly, and they make that point more clearly later, but what we say crucially here is that if one wants to value the shift only and allege that there's an unfair price overall, then one has to value the part of the bargain that pre-existed. And that's what, on any reading of section 4.5, they don't do. That's the cusp analysis. I'll come to this in a second. But we do agree with the earlier part. That,
Yeah.
And then at Roman...
But can I just get your position? Do you think the last two lines are wrong? Because it's a moderation of the earlier position. It's not increasing prices, increasing the demand you make from your users is not in and of itself an abuse, but it is, or it may be relevant.
Well, I would accept that if one was measuring the overall price and the overall value of the full product, then one could, of course, have regard to things that have happened along the way. If that's what the paragraph means, then I would accept that they shouldn't be disregarded. Mm-hmm. So for example, in the hydrocortisone matter, there was a discussion of the Matterhorn of prices. One was looking at how prices had moved over time. So I would accept that things that have happened over time can be taken into account, but only as part of the overall analysis, which is what is the overall product and the overall price. So it's not something that we would say should be disregarded entirely, but it only arises as part of the overall picture. And then at Romans 7, the United Brands test is not intended to be read as statute. Whilst we consider that a purely incremental price increase would be difficult to be characterised as an abuse of price, that is not the case that is being advanced. And this is where we say the tribunal has misunderstood the expert evidence. They go on to describe, the position is said to be this: the Facebook product was profitable at no monetary price using only on Facebook data. The service needs some data. That's very much not the case. And then the tribunal says, depending on how the Facebook offering to users has evolved over time, one can see how an excessive unfair price might be derived from an incremental increase in price. And then they go on to say, if, by example, the original price can be said to be on the cusp of excessive and unfair, then extraction of additional data might be said for that reason alone itself to be excessive and unfair. So what they're saying is, theoretically, if one were in a world where the original bargain between users and Meta was on the cusp of excessive and unfair, then something might happen to tip the balance. But the difficulty with that is you still need, in my submission, to conduct an analysis of what's described as the bargain before that change. You can't start at the change. I think my Lord Justice Green said to me earlier, you can't start the inquiry at the moment of change. One needs to look at what the position was before that, because ultimately one's measuring the overall relationship between price and product. And if I could show you the permission to appeal ruling.
Can I ask you this, for the purpose of certification, what's an assumption in your favour as to the 2014 shift? If the CR starts with the assumption that everything was fair until that point, isn't that an assumption made in your favour?
Well, my Lord, our position is the consumer surplus was so great before anything changed.
Well, you would want to say that there was an imbalance as of 2014 and Meta was entitled to charge a lot more because actually the user was getting an unfairly reasonable deal.
I mean, exactly. One's actually in the world now of reversing the burden of proof in my submission. But what we're saying really is...
Forget burden of proof.
But what we're saying is there's this huge surplus which predates, before off-Facebook data tracking starts in June 20, for advertising purposes, they say in June 2014. What's the position? If one's measuring or trying to look at the relationship in United Brands terms, we would say, well, there's a particular price that has to be defined, and then one has to value the Facebook service. And we would say, and Professor Scott Morton herself refers to the literature, there's a huge value that consumers or users attribute.
I understand. Yeah. I mean, we're not arguing the facts here.
No, but that's what we would say.
We allow it to go that far.
And so if there is a change, then yes, that might alter the overall bargain, but there's so much headroom, if I can put it in that way, that actually it wouldn't alter things. But their case, my Lord, crucially, when the boot's on the other foot, crucially, their case only works to start at 2014 if everything's on the cusp of being unfair.
So So the error in this paragraph is the word generally.
It's twofold. Well, it's generally. It's also relying, because we say it's exclusively. It's relying on the idea that United Brands is flexible, because we say that's a different issue, flexibility as regards methodology, as opposed to the correct framework. And we also say, insofar as the tribunal has said that the approach is not the incremental approach, that's also wrong. And one sees that very clearly in the permission to appeal ruling, which is in the same bundle. Paragraph, if I could show you,
Where in the bundle?
page 90, my lord. Paragraph 6, bottom of page 90. The Messer defendants contended that the CPO judgment erroneously finds it's legally permissible to have the incremental approach. They raise the authorities were not addressed by the tribunal in the judgment, and we've seen that in paragraph 25. None of the authorities were cited. Then they say at 7, the tribunal's very familiar with the authorities, including at the races, Finn, Farmer, Scanlines and Kent. The judgment squarely addressed the issue of whether an incremental price increase could be assessed under United Brands. It was acknowledged that generally speaking, again, we say that's wrong, and they say, generally speaking, and that incremental increases are not the way that jurisdiction has typically been seen. So in that regard, we do actually agree, but we say it's exclusively the position. But then, my lord, they say the CPO judgment went on to explain why the case is not one purely of an incremental price increase. And we say that's a misreading of the evidence, or a misunderstanding of the evidence. And then 8, in any case, the United Brands test is flexible, and its application will vary depending on the context. And my lord, I do repeat the point I made about at the races, which is there are limits, and the flexibility does not, in my submission, justify an erroneous approach to economic value. So, my lord, once the submission really, in short, is once one has properly understood what they're doing, there is a crystallised point of law, and that point of law will arise at the end of the trial, and therefore the court should grapple with it now. And this is, at the end of the day, an amendment application.
Yep.
Just to be, perhaps, just finally on ground 1, the case that one's dealing with here is very different to some of the other certification cases that have arisen. So in the Ro-Ro case, the McLaren case, for example,
McLaren, yeah.
the court ultimately held that that was a matter that could be dealt with by way of case management. But crucially, the reason the court held that was that one could see that what was going on in McLaren was the court held there were competing theories of pricing on the facts. And so again, I do accept that if we were just here saying, well, we disagree...
You said to point of law.
Exactly.
Yeah, no, I mean, McLaren was competing facts, and we were concerned the CAT hadn't grappled with them.
Exactly.
And that's why we remitted it to have another go and introduce this rather confusing concept of a blueprint.
But in order, I mean, I think the solution of case management there was because the battle lines have been drawn as regards the facts.
That's right. Yep.
Whereas we say here, nothing's going to change between now and the end of the trial. And that's why the Court of Appeal should, as I say, there is not a single authority that supports their approach. And we say the court should consider this. If we finally on ground 1, if this approach were acceptable, we do submit that it would be a sea change in the law, because it would materially change the way in which unfair pricing cases are pleaded and proven, and that would affect not only collective litigation, but also individual litigation, and also the practice of the regulators. There's just simply no support, either as precedent or principle, for the incremental approach. Can I very, very briefly make some further submissions on ground 2?
Yes.
And for this purpose, given the time constraints, I may very quickly take you back to the Professor Scott Morton's report, just to show you 3 references.
Just give us the headline point that you're making.
Yes.
What's the error of law?
The error of law here is that the tribunal correctly identified that the class representative has pleaded two abuses, and they are said to be
Oh yes, this is the point you identified at the beginning.
Exactly.
Yes,
exactly.
It's if ground one, if pricing fails, there's really nothing in a pure attack on Tioli.
Exactly, and I was just going to show you, but perhaps you want to hear from Mr. O'Donoghue, but I was just going to show you there are some very good references in Professor Scott Morton's report, where she makes it absolutely plain that her model is premised on both abuses being proven. And because the pleading simply cross-refers or adopts what she says, it follows that that which one sees in paragraphs 175 and 176 of the pleading, that counterfactual only arises in a world where they succeed on both abuses.
I mean, it boils down to this, that it can't be an abuse to impose a fair term.
Well, we obviously do agree with...
But if you're right that the price is fair, then the deal which was imposed was fair. And if it's take it or leave it for something which is fair, then it's pretty difficult to say it's an abuse.
Exactly.
That's the essence.
Exactly. And what you can't do in our submission is you can't simply put forward this counterfactual with an expert methodology that assumes, and then say, oh, but don't worry, if we only win on the unfair trading term, that works too.
Give us Professor Morton then.
Well, just the key references, my lord, where this point is actually, one sees it in a number of places, but perhaps the best examples are paragraphs 22. Sorry, it's a supplemental bundle, page 212.
Yes, we've got it.
Paragraph 22. This is the introduction to her report. I use the bargaining model to consider a counterfactual scenario, and where Facebook has to make a value transfer to users. So that's the value transfer to redress what she says is an unfair price. I believe this provides a good benchmark, and then importantly, it removes the take it or leave it element and the payment of a zero price. And at the end of that paragraph, thus it provides an established framework to consider what constitutes a fair bargain. And the reason this is quite confusing is because they refer, both the expert and in the pleading, they refer to these abuses being two sides of the same coin, or it doesn't really matter how you legally classify them. But with respect, they are pleaded as distinct infringements, and they give rise to very different counterfactual questions.
Yes.
And they try to run them all together. And at 301, which is page 279, she says the bargaining model provides a framework to switch off the key components plural, of the abuse, and hence determine what would happen if it had not occurred. And then she talks about the unfair bargain being arising, one, out of the lack of meaningful competitive alternatives, and two, the decision by Facebook to require the tracking as part of the take it or leave it offer. So she's explaining her own model here as switching off both aspects of the abuse, switching off the key components of the abuse.
Okay.
And then 425, I think, is another very good example, which is page 313. From an economic perspective, I believe the issue of unfair pricing and unfair terms are closely related, effectively two sides of the same coin. What she really means is they will stand or fall together, because she then says the bargaining model effectively quantifies the impact of these two issues simultaneously. So the two abuses here are being switched off, and that's the model. And
so 426, you say she's essentially agreeing with you.
Exactly. But what she then goes on to say, in sometimes in her first report, and also in her second report, she says, well, it's pretty unlikely we would only win on the unfair trading term, but not the unfair price. But if that's the position, my model can be adapted. And what that really fails to recognise is the model is contingent on adjusting the value transfer.
I get everything you've said. Just help me with this. An exploitative term may be fair for non-price reasons. In principle, yes?
Yes.
So could you have a situation whereby the price was fair, but it was the sort of data that a user just didn't want to disclose, highly personal, sensitive data? They could say, all right, well, you're offering me a fair price, but you're extracting this highly sensitive data. I know the skeleton highlights some of those flagrant extractions of personalised data. But I might say, well, price is absolutely fine. I just don't want to give you that. It's too personal to me. Would that be an abuse?
Well, first of all, the skeleton takes a lot of things out of context. But
just
answer,
in principle.
yeah, to answer your question directly, the difficulty is they need to show compensatory loss here.
But for aggregate damages, I see that.
Well, for any damages, if one's even in an individual case.
Yeah, but people might seek a declaration or a declaration of nullity or something like that.
But that's not what's being said.
No, I understand they only want money here.
Yeah.
Yeah, but in principle, just stand back in principle. I get the point about money.
Yeah.
Would it be an abuse to take something by force, as it were, tioli, when the price was fair, but the user simply just didn't want to give that data?
Well, my lord, it's very difficult to answer that sort of question in the abstract because these points are so fact sensitive. But we obviously don't accept that the tioli condition, as they call it, is an abuse. I mean, we absolutely...
On the facts of this case?
Correct.
Or the way in which it's been put, perhaps. We don't need to fight a case which hasn't been put.
Well, I mean, what's being said is they have no choice to give their off-Facebook data. We don't actually accept that. Even the tioli label we don't accept because one actually has to look at all the terms in the
No, I know. Yeah.
If they want to say the price was fair but there's some qualitative issue with the term, then they need to articulate that. But more importantly, for present purposes, they cannot, we say, proceed to trial on some basis which doesn't sound in damages.
No, but there's no point in certifying something which doesn't have a
correct
financial element to it in this collective proceedings context.
Correct. Nor actually one couldn't really understand why they would be pursuing it if there's no compensatory loss.
No, understood.
My lord, it's simply not an answer. We say. I think just to refer back to your provisional conclusions on this point, you said, well, one answer might be to ask for further clarification. But with respect, we understand the case is being put. They've had ample opportunity to clarify. They've steadfastly refused to do so.
Yep.
Nor have they confirmed that no loss flows just from the unfair trading condition. They've actually doubled down and say they do still seek the damages. And then the second point was I think, indicated that the case could simply fail at trial. And well, we say, well, this is an amendment application, and if we're right on this point, the court should grapple with it now, because the one thing this court, or the court must do at the certification stage, given the gatekeeper role, but even more generally, given the importance of pleadings, one can't simply let this case drift all the way to trial without us actually knowing what is the chain of causation that is said to flow from the tioli point. And my lord, appreciate your time, unless I can assist any further.
Thank you very much indeed, Mr. Singler. Mr. O'Donoghue.
My Lord, it is useful to start with reminding ourselves we're in the territory of strikeout. And one could be forgiven in listening to Mr. Singler. We were on the cusp of a trial. Now, Mr. Singler is right that we do emphasise the flexibility in the unfairness abuse case law. I'll come on to his point about that not extending to methodological issues. But it is in my submission very, very important to start, given that we're in strikeout territory, with just how flexible the case law is. Now, we can pick this up in your Lordship's judgment in Pfizer and Flynn, Authorities 1, starting 63, on page 137. And what your Lordship has done helpfully there is distill United Brands. And 63, paragraph 253 is important. There are other economic ways of devising rules determining whether a price is fair. As such, this militates strongly against any suggestion that the test in paragraphs 251 and 252 is to be construed as if it set down a fixed and definitive methodology. 64, commentators emphasize they need to be read contextually, not over-rigidly. These ambiguities matter only if one reads the guidance in United Brands in a dispositive, literal, and rigid manner. It would be wrong to read this passage too literally. The Court of Appeal observed that the judgment had to be read and applied with care. I agree, and then your Lordship gives 3 examples of the ambiguities arising under United Brands. We then go to 147, paragraph 97. under little Roman 3, your Lordship says, there is no, so this is a distillation of the principles from the authorities. There is no single method or way in which abuse might be established, and competition authorities have a margin of manoeuvre, unlike, as we say, claimants. Then 4, depending on the facts and circumstances, authority might therefore use one or more of the alternative economic tests which are available. There is, however, no rule of law requiring competition authorities to use more than one test or method in all cases. And then, my Lords, of 184, the Chancellor, as he then was, at paragraph 244.
Hang on, just one second. So, yes.
Which paragraph?
My Lord, it's 244.
So this is Sir Geoffrey Vaughn. This is the Chancellor at
244.
244.
He says neither United Brands nor Latvian copyright should be read as deeds. And in a nutshell, Mr. Singler's submission is that when one sees the word the product in United Brands, one must read that as a deed, and it can only ever, in all cases, mean the entire product. We say as a starting point that is guilty of the basic sin identified in numerous cases, that United Brands is not a deed or a statute or to be read rigidly. Now, we also say that point is a fortiori in the context of what is a developing area of the law. Your Lordship may recall the case of Intel and VIA, where the Court of Appeal said in the context of strikeout that one should not be in the business of striking out in areas where the jurisprudence is developing. And even as we speak, in the context of data in particular, the jurisprudence continues to evolve and adapt. And I can just hand your Lordships up a recent press release. It relates to one of the cases we referred to in the claim form. It's a commission press release, just to...
European Commission, is this the Austrian case?
Well, Lord, no, it's the preliminary finding that Meta's pay or consent proposal late last year contravenes the Digital Markets Act. Because, of course, one of the points Meta has made is, well, had we not done what we had done, we might have forced users to pay if they did not consent to handing over their data. And the Commission's preliminary view is that that is a contravention of the Digital Markets Act. So the point isn't whether this is right or wrong, is that all of this in the context of data in particular is very much in flux. It is manifestly a developing area.
But does it really help?
Well, Lord, it is a very important framing point, which is that when one is in the realms of strikeout, say in an area which is, we say, rapidly developing in a data context in particular, one should, we say, be cautious. So it is background, but we say it is important background.
This was under Article 5 of the DMA.
5.2, my Lord. Yeah. And of course, what 5.2 says in a nutshell is that if you are gathering off-platform data, you need to have specific consent.
Yes.
So that is a very neat encapsulation of the idea that a demand for off-platform data may well be unlawful. So that's by way of background. Now, of course, your Lordships will also understand the German Federal Supreme Court in the Meta Germany case has found that liability in the context of unfairness is at least well arguable. And your Lordship went through the unfairness authorities in Goodman case in some detail. Now, one final point on the theme of development, if we can quickly look at the Meta Germany GDPR case, it's in the second authorities bundle, tab 24.
Sorry, this is the GDPR case.
The Meta Germany case.
Where's that found?
It's in tab 24 of the
Tab 24.
a couple of references. The first is 1164.
Sorry, I'm just catching up. I'm so far. Sorry.
Which tab? The whole thing's come apart, you need to be slow. Which tab?
My lord, it's the remnants of tab 24.
54.
24.
24.
Yeah.
My lord, it's 4748. A GDPR violation may be relevant to whether the abuse has been committed.
Sorry, which?
Lord, it's on page 1164, paragraphs 4748. GDPR violation may be relevant to whether there's an abuse of dominance. And then at 151, page 1179.
Sorry, I'm just hold on one second.
It's the last sentence of 47 you want, isn't it?
My lord, yes, thank you.
Well, one would need to know an awful lot more about this case to put abstract sentences in context. If I read further, it will probably tell me that apple pie is a good thing. You know, I need to know a bit more than that.
Well, Lord, it's a basic point, which is that a GDPR violation may be relevant and material. Whether there's an abuse, depending on the circumstances.
Be a vital clue.
Yes, a vital.
I need to know what the circumstances there, what kind of clue is provided, but it doesn't seem to me to help really.
Well, we get a bit more help from 151. It's in 1179. Here the point is being made that the processing of Facebook platform data may again be subject to a requirement for separate consent.
But is that a GDR point? I don't see how this helps
Well, Lord,
at the moment in assessing whether or not there's been an error on the part of the CAT by excluding, if that is what they've done, the assessment of part of the value of the
Yes.
service in question.
yes, well, I'll come to that. We say they haven't.
What does 151 tell me then?
Well, that the processing of Facebook data without having sought separate specific consent may be a GDPR violation. And well, the reason I mentioned this, of course, is we have pleaded GDPR violations in the context of the competition claim. It's at 101 and 103C of our claim form.
Okay.
And well, so that's by way of, we say, important context. But, my lords, the essential response to Mr. Singler's point is that it is based on a mischaracterization of the class representative's case. The class representative's case, it does apply the United Brands framework, and it is simply wrong to say that it is based on what Meta characterizes as an incremental approach. And one can see this very clearly in my submission from the pleading itself. If one goes to the tab to the supplemental bundle, and my lords, it starts at 163. As your lordships will see under D, we are expressly pleading United Brands, and we set out the various limbs in Roman 1 and 2. And then 3 is important because, as your lordships will see, the focus under limb 1 of United Brands is on the entire profitability of the platform overall, 1, and then 2, of course, we do then have regard in addition to the incremental contribution of off-Facebook data to that profitability. Now, of course, we would have been criticised had we not done that, because if off-Facebook data was worth the sum total of £1, then focusing on the overall platform profitability wouldn't be much of a point. So one sees straight away in Lim 1, we're looking at profitability of the platform overall and not an incremental measure. Then if one goes down over the page to Lim 2A of United Brands, under Roman 4, 1, we say, is looking at the service overall.
Sorry, I'm just making a note. Give me that paragraph again.
Well, it's 164. It's under little 4.
Yep.
Subparagraph 1. So 1, we say, is looking at the service overall. 2 over the page is, we say, fairly and squarely rooting United Brands. The question is, what would the bargain look like between Facebook and the users under conditions of normal and reasonably effective competition? 3 is important.
Sorry, just so the product overall comes what from line 5 and 6 of 1.
Yes.
Reasonable relation of price with the economic of the services to be applied. Is that?
Indeed.
Those are the key words.
Indeed.
So that's the services, i.e. the Facebook service as a whole.
Yes.
And 2 in the 5 lines down, a more equitable bargain, is that overall or just in relation to the offer?
Overall,
of
mate.
Facebook?
Well, overall.
Overall, okay.
Then 3 is important because what 3 gives you is a classic before and after comparator of the kind routinely used in unfairness cases. So 3 says, when you didn't have market power, you attempted to impose off Facebook data tracking, and you had to reverse those measures. And it was only when the market tipped into dominance, we say monopoly, that you were able to get away with the extraction of these data. So that is we say, a classic United Brands. And to go back to my Lord Justice Green's pharmaceutical example, you have a pharmaceutical product which cost 5. Then all of a sudden there's this dramatic overnight price increase to 100. And the question is that before and after difference of 95 justified by some change in circumstances? So we say at base, our approach is a classic before and after analysis. 4, we highlight the point of complete dependence, which is fundamental in exploitation cases. 5 and 6 are important. There is a lack of transparency in the choice architecture of the Facebook service that obscures users' ability to make informed choices and to effectively withdraw their consent. And indeed, we say that users were misled by Facebook in terms of public pronouncements, suggesting they were not engaged in off-Facebook tracking, when indeed they were. And then 7 over the page concerns the ATT, very low opt-in rates for off-Facebook data tracking on Apple devices. What this shows, again, is classic United Brands. If users are given a choice of control in respect to their data, very, very few would actively opt in to off-Facebook tracking, certainly we say, without a financial inducement. Then if we go to (2B) at 168, again under 1, classic before and after.
So which page? I was just reading the rest of that paragraph.
Well, forgive me, it's 168.
168. Oh, yes.
So now we're on
I
to
was reading.
Lim 2B of United Brands.
Yeah.
So again, the suggestion that we are on a frolic of our own outside United Brands is manifestly wrong on the face of the pleading. So under 5 is 2B. 1, again, before and after comparator. Two is again AT&T. And 3 is important, because again, it is classic United Brands. We say there are comparators, credit card companies and the like, who are in the business of making financial payments or payments in kind to users, and we rely on those comparators as evidencing what would happen under conditions of normal and sufficiently effective competition. So we say all of this is more or less traditional United Brands. There's nothing exotic about any of this. And the same points are put in the summary at S16 to S22. And we say that is how the CAT understood the pleaded case. If we go, for example, to the permission to appeal ruling in 5, the core bundle, it's on page 91 to 92. We say, for example, at 7, last sentence, PCR's case is not one purely of an incremental price increase. Then at 10, they applied the principles of United Brands in a manner which would be triable. Claim form applied the test in a before and after analysis of the kind routinely applied in unfairness cases, and Professor Scott Morton's report compares the features of Facebook's behavior when there was some competition with the period following the tipping of the market into dominance. She considered the profitability of the entire Facebook platform and the contribution of Facebook data to its profits, and included analysis of the assessment of economic value of Facebook. The PCO applied the two limbs United Brands, considering overall incremental profits under 1 and other contextual matters under 2. More detailed arguments as the parties approach to assessing pricing is forthright. So the tribunal certainly understood that we were applying United Brands in essentially a traditional form with some minor modifications for the data context. Now, in my submission, what Mr. Singler's submissions exposed is essentially he's given you a preview of all the things on economic value that Meta will wish to argue at trial. And his case, clearly, is that at the point in 2014, users were already receiving, in his submission, I think, excessive economic value, and Meta says that needs to be factored in to the analysis. Now, the long and the short of the debate today is the CR and Professor Scott Morton, they do not agree with the factual premises of that analysis. And I'll show your lordships where Professor Scott Morton has analysed this. And in my submission, it is a very strong thing indeed to say that when one is concerned with the question of economic valuation, one is in the realms of strikeout territory. The valuation of a thing is a quintessential question for trial. And in my submission, Mr. Singler's submissions, they almost prove too much, because what he didn't show you was any evidence in his economist report, for example, supporting his submission that at the point of off-Facebook data extraction in 2014, users were already being excessively compensated by Meta. And of course, had he done that, he would have, in effect, got a machine gun out to his own foot, because he would then have highlighted my point, which is all of this is for trial. And in my submission, he can't be in a better position by simply making an assertion in the context of a permission hearing and saying that that assertion is so powerful at this stage that the entirety of the CO's case must be struck out, plain and simple. I'll show your lordships this, but these are quintessentially matters of valuation, of fact, of argument, factual evidence, economic appreciation, and of course judicial evaluation. They're for another day. Now, just to make good that.
So is your case really that, looking at it, what might broadly have been at least not an unfair situation in 2014, the shift and the squillions that are coming in for Meta raise the question as to whether or not it is now or has become an unfair situation. And if they're trying to say, no, in fact, you've been lucky all along, for years you were getting a big benefit which we gave you as a corporation at a massive reduced rate, they can argue that on the facts. Is that it?
Indeed.
Oh, right, okay, just so I got it then.
Yes. And my lord, that analysis is a classic before and after. We say the before point of 2014, that is a benchmark for fairness, and we say the after period then tips into monopoly, and there's this massive data extraction. And that is a before and after analysis, and we say that is fairly and squarely within United Brands. And I'll give you lordships of references, but what Professor Scott Morton says is, well, Meta's economist Dr. Parker alludes to certain possible valuations left out of account. He has very studiously avoided giving anything concrete. These are very high-level assertions. And she says, if and when those alternative valuations come forward, she will take them into account and they can be factored into the analysis. So your lordships can see already the battle lines in terms of case management and trial in this case are very, very clearly drawn. And Mr. Singler says, even by 2014, users are being excessively compensated, and that will be part of their case on economic value. We disagree as a factual matter, and we've taken into account, we've analysed, as I'll show you lordships, a number of developments, and we say that these don't justify the new and onerous data extraction price. So that is the battle lines for trial. In my submission, it is manifest. That is an issue for trial. It's not a legal point today that is of sufficient clarity and tractability. One can tip over the whole thing, or even grant permission on the basis. But let me show you what Dr. Scott says. If we go to the supplemental bundle tab 3, please. Well, we can start at section 4.5 on 269. Forgive me, Lords, if we can start at 267, please. This is the United Brands point. So if your Lordships look at 241, for example, she puts forward 3 comparators. The first is the before and after comparator, which I've shown you. She says the pre-2014 period gives you a benchmark for what a competitive market might look like. And then she says that there's been a tipping into uncompetitiveness. And then 242, so that is the question of changes in the dominant firm's practices over time. Again, we say classic United Brands. 243, before this market tipping, Facebook did not impose the same terms and conditions, required users to agree to off-Facebook tracking. The second comparator, 244, is the point I've mentioned. There are examples of credit card and indeed social media companies who do not impose terms and conditions of a similar kind. And then 250, there's a series of other comparators which compare credit card companies, food delivery services, ride-sharing companies, and so on.
These are all the sorts of comparators which I remember we discussed in Flynn Pharma.
Well, indeed.
They're fairly traditional comparators.
indeed.
They're just evidence.
It's just evidence. And these are not exhaustive categories. In principle, any relevant material comparator can be put forward. The suggestion that this is sort of closed, exhaustive, rigid is simply misconceived. And it underscores the point. This is all quite granular stuff for trial. We need to interrogate, in particular, under the first comparator, the shift, the tipping point. There'll need to be disclosure on that. On the second comparator, we'll need to do a compare and contrast of terms and conditions across other platforms. And then 3 will be comparators in other, we say, analogous markets. So all that we say is obviously for trial and is manifestly not in strikeout territory, or indeed anything close to it. And indeed, if one takes a step back, I mean, if one took a garden variety United Brands case, in my submission to go to this court, or indeed the CAT, and say, well, I can essentially have a strikeout judgment in my favor on the basis that each and every one of these comparators would be insufficient to get you home. In my submission, that would be a very, very bold submission indeed. And my submission ought to be given short shrift. So these are matters of detail and granularity for trial. Now, if we then go to 4.5, again, it is a mischaracterization. It is not the case that Dr. Scott Morton has some religious tenet that she would only ever look at an incremental price and nothing else. It is a reasoned, fact-based, analytical conclusion she reaches, considering a wide range of different factual and other matters. And indeed, the submission that the class representative hasn't looked at economic value, even looking at the heading, is quite an ambitious one. You have an entire section which is only about economic value. And we then unpack it. So there are a series of sections. The first is at 255, the heading. Can the data extraction be justified on the basis that Facebook is significantly valued by users? So that's Mr. Singler's point, that users love the service. They were in fact being overpaid, and they should be content with that. Now, Professor Scott Morton, again, on the basis of analysis of facts, not dogma or religious tenet, says, well, on my analysis, I do not accept that is necessarily so. So you see, my lord, for example, 258, she says, much of the willingness to pay likely to result from network effect, lack of alternatives. She says, again, we say an intuitive point, in a reasonably competitive market, you don't bake in the monopoly, the network effects, and the lack of alternatives, the dependence. So that is we say, a perfectly sensible conclusion. And 259, she says, some of these effects, based on her analysis, come from addiction effects, and she say one shouldn't bake those in either. 260, she says, much of the functionality predates the intensification of off-Facebook tracking. Off-Facebook tracking is not necessary to develop these benefits, given Facebook is already profitable. And at 261, so again, it is not because of some dogmatic position on her part that she has reached that conclusion. It is based on factual analysis of the elements of this service, including the service as a whole, the addictive effects of the service as a whole. And if one then goes over the page to 272, she has a further section, which Mr. Singh has skated over. Can the data extraction be justified on the basis that Facebook improved the quality of its service commensurably in other respects? And again at 266, 267, 268, she analyzes pre-disclosure based on public materials, whether these alleged improvements justified the higher price. And she says no. Then there's a third section starting 269. Can the data extraction be justified on the basis that data extraction directly improved the quality of the service to users? And she says, in my preliminary analysis, the off-Facebook data is not directly used to improve the service to users. And then a fourth subsection at 270, can the data extraction be justified as the fruits of Facebook's prior investment? And she talks about a conventional one-sided case and then a two-sided marker open page. And she says 271, my initial assessment of this justification does not apply in the present case. First, Facebook was already significantly profitable prior to the use of Facebook data tracking. So again, she's looking at the service as a whole, and she looks at the EBIT margin. And then she says Facebook could still have been significantly profitable in the world where it relied on contextual advertising or access of Facebook tracking with consumers' informed consent and providing them fair compensation. And then she says, overall, my preliminary conclusion is that I do not see Facebook as creating economic value to users which justifies its conduct. So she has, as best she can pre-disclosure with public materials, gone through the facts and the analysis and reached a reasoned conclusion on economic value, including across the platform as a whole. And her preliminary conclusion is that there is no economic value to users which justifies the conduct in question. Now, we then look at Dr. Parker's report from tab 6. And it's conspicuous for what it doesn't say. It doesn't do what Mr. Singler had alluded to this morning, which is to set out in any concrete manner the reasons why Meta says that by 2014, users were being excessively compensated based on the value of the service. There is nothing of any sort by way of evidence or analysis on that. It is a vacuum. Now, Dr. Parker is, of course, entitled to keep his powder dry, as is Meta. But in my submission, it is then not open to Meta to say that, in effect, all of Professor Scott Morton's quite detailed factual analysis can be effectively struck out. And it was a very curious feature of the submissions this morning that most of Mr. Singler's time was, in effect, spent trying to strike out an economic report. And that seems to me a very topsy-turvy approach to a question of strikeout. Now, there is nothing which makes good Mr. Singler's points in Dr. Parker's report. And if we then look at the second Scott Morton report, it's in tab 7, and it's at page 520. And if we start, my lords, at 31, she says, my first report has a section analysing why, in my view, the essential figures of the service have remained materially unchanged since CPU started, and therefore the principal change in the bargain is the imposition of off-Facebook tracking on users. Given this analysis of my first report, I find it surprising Mr. Parker does not put forward any evidence showing what specific improvements in Facebook service I have failed to account for. Given the asymmetry of information between myself and Facebook at this stage, Mr. Parker, with the assistance of those instruct him, in the first instance, is best placed to specify the service improvements which he has in mind and how they should be quantified. Fourth, were Facebook to put forward evidence of any service improvements post-certification, I would, of course, carefully evaluate that evidence and determine whether it is sufficiently convincing to justify incorporation into my bargaining framework. As I explained above, my approach does not preclude Facebook from seeking to make such arguments, and my bargaining model is flexible to incorporate such consumer benefits as are found to exist. Fifth, as I said in my first report, whilst I do depart to accept such academic studies concerning Facebook's value to consumers, it is clear there will likely be significant disputes between the CR and Facebook as to whether the alleged value users place on Facebook represents a legitimate benefit or instead reflects the lack of competition it faces and the lack of alternatives, as well as potentially being attributable to issues such as dependency and addiction. In particular, a significant issue will be how to account for the value derived from network effects. My view, based on the evidence available pre-disclosure, these network effects were already substantially present before the imposition of Facebook tracking and so on. So, my lords, all this is to underscore that the battle lines are already quite well drawn between the parties. It is clear that Professor Scott Morton will be focusing a lot on network effects, the issue of addiction effects, the question of the tipping point. It is clear that Meta, by contrast, will be saying that already by 2014 users were effectively overpaid, and that will be the battle for trial. And what Mr. Singler, in effect, wants you to do today is, on the basis of a complete vacuum in Mr. Parker's report, and having read the two Scott Morton reports, to say, in effect, you must assume today, in a strikeout context, that his case on the value to users in 2014 being so exponentially higher than the price users paid, you should assume all of that in his favour as a matter of law. And in my submission, when one puts it in that way, it is an unstateable proposition. We are in the realms of granularity, evidence. There are disputes. I don't shirk from that. We may well be right, we may well be wrong. That is all the trial. To say that, in effect, your lordships today can conduct, with finality, a valuation exercise and assume everything in his favour, in my submission, is a bridge too far. So, that's all I want to say on ground one.
Very quick on ground two, the essence of the response.
Well, my lord, we say it's very, very simple. If you can't take or leave the data, and there is we say, a breach of transparency in the way these data were effectively sequestered, in a counterfactual, given the economic value of these data of the order of billions, you will have to incentivize the users to give up their data. So it is an economic rationality point. You are making tens of billions in economic profits. It is economically rational for you to offer an inducement to users in circumstances where you can't effectively take the data by a contractual fiat or by an abuse of transparency.
I don't think that's challenged. I think the point is, if perchance you were wrong on finance, so that in fact the term was ex hypothesi, absolutely fair throughout.
Yes.
Does the Tioli point add anything to the collective action?
It does, if only for the transparency reason I
Does
adverted
it get you any money?
Yeah, what's the loss?
Well, it's that in the presence of transparency, users would have been able to bargain effectively and choose not to give their data to Facebook, and the bargaining would then have proceeded on the basis that only financial inducement would have unlocked their consent.
But let's just, I mean, I see that. Let's assume you're wrong on that, and there's absolutely no aspect of this case which turns upon you getting any money whatsoever. I mean, it may be that's really just a hypothesis which needs to be tested at trial, because I can see that the two have an interconnection in relation to the financial aspect of the case. But let's assume, theoretically, maybe entirely abstract, theoretically, there was zero benefit financially to be gained from a negotiation. In practical terms, does Tioli add anything to the analysis?
Well,
I mean, even if you said, no, it doesn't, that may not mean we strike it out, because it may just be so interconnected and interwoven with the facts so that it's just sensible to leave it and see how it runs.
yes.
But theoretically, is that if you're entirely 100% wrong on the money, does it add anything?
Well, it must do. Again, if one can't simply take the data through this contractual fiat, the users then have the possibility to say, no, I want something in return.
But we're assuming you lose on that. In other words, there is zero benefit to a user. I mean, I think logically, if there was zero benefit, then you could see that, you know, which of the Consumer Association might want a declaration, or there may be unfair terms and conditions and other things. But in a collective action with an opt-out aggregate damages class, that it presumably, theoretically, doesn't add anything. I mean, you may say, so what?
Well,
In that extreme situation.
It is extreme. Of course, we may well then be in the realm of saying that the profitability is a proxy for the damage to the class. So it may require some modification of the measure of damage. That is one possibility.
But we're assuming that the money aspect fails completely. There's no abuse. If we could translate both on and off data into a monetary term, call it X, and X is absolutely fair in all circumstances,
Yes.
then I don't think Tioli adds anything. It's
Well-
not. Is it an abuse to impose a fair term?
Well, it may not be an abuse not to pay, but the way in which the data are extracted through these terms and conditions and lack of transparency, that of course can be an abuse in its own
I
right.
see that.
And we
my
say
broad
that
point was, but in the context of collective financial proceedings, This isn't a standalone action for a declaration.
Yes. Well, Lord, it may require us to argue that the profit to Meta is a proxy for the loss to the class. That is one possibility.
It's not on this analysis because the profit they get is what they're legitimately entitled to. It's fair on this analysis.
Yeah.
Well,
You would only be able to get some sort of disgorgement if there was an abuse, but we're assuming ex hypothesized to test the argument that there is zero abuse in any aspect of the monetary claim or the way in which Meta is imposing charges in the form of its alternative consideration, namely data. On that hypothesis, I'm not certain this adds anything in a collective action context. It may be, and it may be that this is just, the two have to be looked at contextually and together because, as is said,
yes.
they are two parts of the same coin, and maybe it all stands or falls together.
Well, again, well, just to, we say this is all deeply factual, and if we can just quickly look at the first Scott Morton report, it's in the supplemental bundle tab 3.
Yeah.
Or it starts at 263.
Is that page 263 or para?
Page.
Yep.
So she's asking the question, would Facebook's conduct have been permissible under conditions of reasonable effective competition, which is the classic United Brands? And then on the question of the realism of the payment, if we jump forward to paragraph 318, please.
It's the same thing. They're not getting something they would have got. But this hypothesis, they're getting exactly what they got. They were lucky not to have had to pay for it for years before, as Mr. Singer says. It's a means of testing unfair prices, but if the price is not unfair,
Well, she notes, my lord, for example, at 320 at page 286, that in the past, Meta has actually paid users for effectively their labour. So the concept of a payment is not an alien one. And the point she's making here is that one can see from these various sources and these various comparators that the idea of a payment for the use of data is not an alien one. And in a sense, if we quickly look at Dr. Parker's report.
So what it boils down to is that it may be an abuse not to provide the option, even if the price being offered is fair.
Yes, that the way in which the choice of the user is removed, the lack of transparency, may be an abuse.
Your quantum, your aggregate damages on that hypothesis presumably be pretty minimal.
Well, subject to my point that the profitability generated by Meta for these data may be a proxy for the loss to the class, but I accept that would require modification of the case.
Is that basically saying it's a disgorgement case?
Well, it may be a matter of degree, my lord, but one can see how if the concept of damages is in practice difficult to work out, that the gain to the defendant might in some context
Well, I think we've
be a
floated
proxy.
that as a vague possibility in some other cases. But
Well, yes.
we've floated it.
Indeed, your lordship.
And the cat wasn't terribly impressed in this case. Anyway, okay, I've got the point.
Yes.
I mean, maybe at the end of the day, it is so interwoven that it all stands or falls together. But I mean, there is some force in the point that if your real thrust in a collective damages case is money, it's dosh.
Yes. Well, in a sense, your
I'll give you
lordship.
2 minutes.
Yes, in a sense, your lordship highlights in my submission what is the incongruity in a lot of what your lordship had this morning. At the end of the day, we're talking about a unfairness abuse. One can look at it in one of two ways. And indeed, when one thinks about it, the concept that the price is unfair because the price paid by users in terms of their data is too high is hand in glove, we say, with the notion that extracting these data from users in the manner which has been done is unfair. So we say that the clear blue water between the two deuces, we say, is more theoretical than real. They are genuinely two different sides of the same coin, we say. One final reference.
Another clue that something iffy may have gone on, really is what you're saying, I think.
Yes. I mean,
That's another way of testing. Is this what really would have happened if there had been perfect competition?
indeed. Lord, that is the simple version of this case. And we don't need to speculate, because we see with Project Beacon, they tried this, and there was user backlash. Only when the market tips in their favour, they can get away with this. We say that is classic before and after. That case is perfectly good enough to go to trial. So Lord, those are my submissions.
Thank you very much indeed.
My Lord, I'll be
You've got
brief.
plenty of time. 3 or 4 minutes max.
So, my Lord, first of all, this is a permission hearing, and what we need to demonstrate to your lordships is that we've got an arguable point of law which merits full exploration at the appeal stage. Now, we've heard a lot today about what is Professor Scott Morton seeking to do and the approach she's seeking to take. And in my submission, she is plainly, in relation to the economic value aspect of the test, plainly adopting the incremental approach. I understand that one might have done it a different way, one might have broken up the economic value and aggregated it, but in my submission, section 4.5, properly read, is absolutely clear. At 261, she says, in her view, the right approach is not to do the aggregate economic value of the whole service. And that's particularly striking because at 253, she has specifically recognised that there was value before off-Facebook data tracking. I mean, it's just a common sense proposition. Before 2014, users were using Facebook and there was economic value. And that our point is not that we are debating what that economic value is. Our point is that the claimant in an unfair pricing case has to ultimately assess the overall price against the overall product. And she therefore, and the class representative is therefore not entitled to wash away the pre-2014 story and say, well, if you, Meta, want to lead evidence and argue at trial that there was economic value arising from some other part of the price and some other part of the service, then that's a matter for trial. We say this issue arises because of the way in which the claimant is obliged, as a matter of law, to frame their unfair pricing case. And indeed, she says at 257 that she agrees there is consumer surplus if one looks at the whole. And yet she sets her face against any attempt to measure that overall bargain in her phraseology. Mr. O'Donoghue's best attempt to defend the approach is to point you in the pleading and in the expert report to sections that have nothing whatsoever to do with economic value. So he takes you to the limb 1 and limb 2, the unfairness and the excessiveness, and says, well, we're doing before and after, and we're looking at overall profitability. But we know from Flynn Farmer, economic value is a mandatory question. The class representative, in fact, accepts that it's a mandatory part of the exercise. But what goes wrong, fundamentally wrong in my submission, is that when they come to economic value at section 4.5, it's purely incremental and it's starting the inquiry at 2014. And I do emphasise the point that it's not right to simply say, well, the case should be allowed to go to trial and Meta can argue whatever they want about economic value at trial. It is more fundamental and it is an anterior point. It's about how the case is put together. And they say, well, we are inviting you to make assumptions about what the economic value was before 2014. I mean, that's a complete mischaracterization of the dispute before you. What we are saying is that theoretically, if one wanted to allege an unfair price and start the clock in 2014, the claimant would need to demonstrate that the nature of the relationship before that point in time was on the cusp of unfairness. And that is the only conceivable basis, as a matter of theory, that one could sensibly advance an unfair pricing case starting midway through the relationship. So this is not a factual debate about economic value. It's about what does a claimant need to prove. And Mr. O'Donoghue rather gave the game away when he started his submissions, because he said United Brands is not a deed and the word product here is being read as a deed. Well, my lords, that is the point of law which arises. The question is United Brands concerned with the economic value of the whole product or something short of the product? And I do stress, at a permission hearing, where what's being suggested would represent a complete sea change to the way all of the unfair pricing jurisdiction has developed, this comfortably, in my submission, meets the hurdle for permission to appeal. And to clear away the other points that are made against us, novelty doesn't change the position, because we're concerned here with the legal test. So novelty might bear upon other aspects in terms of how the case might be proven at trial. But as to what one needs to prove, the novelty or the role of data doesn't assist, nor do these references to the flexible test, because that's all about proving the unfair price at trial, and we say the framework is incorrect. Nor, my lords, is this a question of, well, won't this be better assessed post-disclosure? That's often an issue that arises. But that's not this case, my lord. In fact, this issue that arises, this pure point of law, makes this case very different to all the other collective cases that have come before this court. Now, if one was concerned with an individual action for damages, one would perfectly well be entitled, and this happens all the time, inside and outside the competition context. You say, well, the claimant's pleaded this very long pleading and says it wants to lead all this evidence at trial, but ultimately they've aimed at the wrong legal target. And one is entitled to say, in an individual case, assume everything in their favour, they will not succeed at trial. And similarly, in the collective context, on a permission to amend application, with the gatekeeper role, in my submission, it would not be satisfactory for this court simply to reject permission and allow this case, this no doubt significant case, to proceed to trial, if ultimately, at the end of the day, the judge will hold that the wrong test has been applied, as in at the races, for example, just a wrong approach to the cost plus versus demand side value. So in my submission, this court should grant permission to appeal on ground 1, as it plainly raises an important point of law and requires full argument. And as to ground 2, I can be very short on this. We do submit a point of law arises, and I just want to make this point. The way in which the tribunal dealt with it was, in my respectful submission, completely unsatisfactory, because having accepted that these were self-standing infringements, they go on to say in the main judgment, well, the answer to all of this is that what's being claimed is negotiating damages, and they cite Morris Garner, the Supreme Court case, in a footnote. I think it's paragraph 26 of the judgment, footnote 21, I think. And then when we pointed out in our consequential submissions that in fact the class representative had expressly disavowed such a claim, the tribunal then says in the permission to appeal ruling, well, of course they're not claiming negotiating damages. This is a traditional compensatory claim, and we can't see how this is said to be unarguable. But my lord, that failed in my submission to grapple with the distinction between the two infringements. And what we've heard from Mr. O'Donoghue this morning actually reveals that there is no answer to this point. There is no chain of causation or loss that's been articulated. The best he could do was to say he accepts there needs to be modification. Well, that proves our point. They shouldn't get permission to amend. And secondly, he said, well, there might be something about profitability. But that just takes you full circle back to disgorgement, which they expressly disavowed, and which the CAT has now recorded was expressly disavowed. So, my lord, for those reasons, we do submit that this court should grant permission on both points. They do raise significant issues, and they are points of law.
Thank you very much indeed. We'll rise for a moment just to consider how we approach the decision. We're very grateful to both parties for their very detailed submissions. This is plainly going to be a complex case, but as matters stand, we're not minded, Mr. Singler, to give permission to appeal. We think this matter needs to be thrashed out. We see some force in the point in your ground 2, but again, we think this is a factual matter which is very largely intertwined with ground 1. That individual ground might fail at the end of the day, but really they're so intertwined they need to be tried together. Obviously, the views we've expressed today have absolutely no bearing upon the views the CAT might take as to the merits. We've simply explored issues. As the CAT rightly said, this is a complex issue, but it will need to be thrashed out at trial. Now, so far as costs are concerned, we're minded to make an order that costs will be in the case to be determined by the CAT at the end of the day. We will give fuller reasons to follow, but we thought it's sensible from a case management perspective to give our decision now. We would be grateful if the parties will reflect that in an order. I don't think anything we say in the reasons would affect the order, and you can simply get on with the matter now. Is there anything else?
Well, I hear what the court says on costs. I mean, we've been, to a lot of time and expense, we've been diverted by 8 months from our trial timetable.
If you win a trial, you might get your costs.
Don't forget, practice direction says you don't normally get costs anyway for getting them in the case. It's quite a triumph, you might say.
Well, I'll leave it at that.
Thank you very much indeed. Thank you, everybody, and thank you, of course, as always, to those behind who we know do the bulk of the work.